With wrestlers continuing their protest against Wrestling Federation of India chief and BJP MP Brij Bhushan Sharan Singh, the calls for the latter's immediate arrest have intensified. We know that Singh has been accused of sexual harassment by at least 7 women wrestlers, including a minor. Wrestling champions Sakshi Malik, Vinesh Fogart, Bajrang Punia and others have been protesting over this for months now. 2 FIRs have been filed, the provisions that have been invoked in the FIRs, and one of the FIRs is the one filed by the minor victim's father under Section 10 of the Protection of Children from Sexual Offences or POCSO Act 2012. Singh has of course denied all these charges and has claimed that the law is being misused and that under the leadership of Sears, they will force the government to change it. Now, the general perception is that POCSO is a very stringent law and it leads to immediate arrest of the accused. But what does the law exactly say, and is an immediate arrest usually the norm in such cases? I'll tell you in this video. So the law was introduced in 2012 to protect children from offences of sexual assault, sexual harassment and pornography. It was revolutionary at the time and still is, because it is gender neutral and regards the best interests and well-being of the child as being of paramount importance at every stage. Now, Section 10 particularly, which is in the FIR against Singh, talks about the punishment for aggravated sexual assault. Now, what does sexual assault mean? According to the law, that is POCSO Act, whoever, and I quote again, you can see the provisions on your screen as well, touches the vagina, penis, anus or breast of the child or makes the child touch the vagina, penis, anus or breast of such person, unquote, with sexual intent, or does any other act with sexual intent involving physical touch without penetration, they could be held guilty of sexual assault. But what is aggravated sexual assault now? Now, the way POCSO works, offences under the law are considered more grave or aggravated if they are committed by certain specific people in positions of power or authority. So, for example, offences are considered aggravated if such acts are committed by a relative, police officer, public servant, any member of the staff at a remand home, protection or observation home, jail, hospital or educational institution, or by a member of armed or security forces. So you get the drift. The offence is also considered graver if it is committed by the management or staff of an educational institution or by the owner or management or staff of any institution providing services to the child or by someone, and I quote again, in a position of trust or authority of a child in an institution or home of the child or anywhere else, unquote. So it has a complete list of such offences or the perpetrators that categorizes the offense as a graver version of the original offense or a more aggravated version of the original offense. So, and what happens when the offense is aggravated? Essentially what happens is that the law lays down a higher punishment for them then. So for aggravated penetrative sexual assault, the minimum punishment is 20 years and could go up to life imprisonment or even death penalty. For aggravated sexual assault, which is Section 10, the convict can be punished for 5 to 7 years. As against this, now compare it with penetrative sexual assault or sexual assault. So the punishment for penetrative sexual assault is 10 years life imprisonment and for sexual assault is 3 to 5 years. So for the aggravated offenses, the penalty is higher. So they're considered more serious in that sense. Now, laws don't usually just mention that a person must be arrested. However, there are norms that are usually followed depending on how serious an offence is. Section 10 of the POCSO Act is a cognizable and non-bailable offence. Again, to break it down for you, cognizable offences are those in which a police officer can make an arrest without a warrant from court. These include offences which are considered more serious in nature, such as murder, rape, dowry death, and kidnapping. If an offence is non-bailable, that means bail is granted to the accused at the discretion of the court and not as a matter of right. So the accused has to go to court to get bail in such offences. So clearly, these are more serious offences, and these crimes or offences, while the discretion to arrest still rests with the police, the accused is usually arrested. That's the norm after an FIR is filed. The offences are also non-bailable, indicating that an arrest usually again follows an FIR in such cases. Especially in POCSO cases, arrest is usually taken as a given, even for offences which are punishable for less than 7 years. This is because in POCSO cases, the victim by definition is vulnerable. Now, there's another defense that is being given for Singh to not have been arrested so far. The Supreme Court had passed a landmark judgment in 2014, and it had issued guidelines with the intention that the police officers do not arrest unnecessarily and magistrates do not authorize detention casually or mechanically. So the guidelines in this judgment include the requirement that the police officer should record reasons for arresting an accused and is expected to issue a notice of appearance in cases involving offences with a jail term of less than 7 years. However, we spoke to a criminal lawyer, Sarim Naved, who explained that the Supreme Court has never said that for cases inviting less than 7 years of imprisonment, there can be no arrest. All they've said is that only that for such an arrest, reasons have to be recorded in writing. Referring to Singh's case, Naved said, and I quote, "In this case, the accused is going around and saying that the wrestlers are lying, they should return their medals. He's organizing rallies. How does this not amount to intimidation of witnesses?" he asked. He also said, and I quote, "At least they should explain why the arrest has not happened,